Hi, my name's Katie Noon. I'm one of the attorneys at the Liker Law Firm. Today I'm going to talk about the basics of the bankruptcy process. The decision to file for bankruptcy is a very important and, of course, personal decision. There are a number of things that you'll want to consider and some common mistakes that you'll want to avoid leading up to bankruptcy. Bankruptcy law is quite complex, and the first thing you'll probably want to do is make an appointment for a consultation with an attorney. At this consultation, we'll take some information from you, we'll evaluate your case, and of course answer any questions that you might have. At the end of the consultation, we'll advise you about whether or not you qualify for a Chapter 7 or a Chapter 13 bankruptcy filing. Should you decide to retain us, one of our attorneys will go over a contract with you. At this time, we'll discuss attorney's fees, possible payment plans, all of your court fees, and any fees associated with filing for the bankruptcy. We will then go over all of the information that you'll have to provide to file. This, of course, will include all of your creditor information and other personal information, including information about assets that you may have. It is advisable to begin working on this as soon as possible. There is a lot of information that we will need from you prior to the time that we can actually file with the court. Once you've made your final payment and attorney's fees are paid, and you have half of your court costs paid, we can file your case. Once we're paid in full, it might take a few weeks for us to actually prepare your petition. We'll then have you come in and sign it, and if you've paid half of the court costs, we can go ahead and file with the court. The most important date in a bankruptcy filing is the date of actually filing with the court. On that date, creditors are legally barred from trying to contact you or making any attempt to collect the debt. If you're currently being garnished, that garnishment has to stop. Now, of course, due to processing, that may actually take a few weeks or pay periods, but you are entitled to a refund for any garnishment taken after the date of filing for bankruptcy. If you're not being garnished or you do have a judgment pending, that would have to stop at that time. So if you do have a potential judgment or a garnishment, you will want to speak to an attorney as soon as possible. Once we filed your case, it generally takes about 4 months until the bankruptcy is discharged. At some point, you'll have an appearance before a trustee. Of course, if you retain us, we'll attend that hearing with you. It generally only takes a few minutes, and they'll ask you some questions about your assets, about various different things. Once your bankruptcy is discharged, you will be notified by mail that you've been discharged. Of course, it's very important to remember that if you have any outstanding issues like tax refunds or anything else, that you'll want to make sure that you correspond with the trustee anytime they ask, even if it's after the discharge letter, simply because the discharge letter does not mean that your case is entirely closed, and your case can be held open for taxes or any other issues. If you still have any further questions, please feel free to call us, and we'd be happy to set up an appointment for a consultation with an attorney.